Hello friends, I welcome you to a brand new video on the channel Law for All. Now in this video we are going to be learning about the extension of prescribed period in certain cases under the Limitation Act. Now as always, before I begin with the video, I would like to point out that I have left some useful links in the description section of this video which are as regards Indian law. So therefore if you would like to learn more about Indian law, then kindly to check out the links in the description section of this video. Now proceeding with the video, today we are going to be discussing about the extension of prescribed period of limitation under certain cases. That is, basically generally the rule is under the Limitation Act there is a specific limitation provided for every act under the Indian law. That is, the Limitation Act is basically based on the principle that the law is for the diligent and not for the indolent. That is, if you are diligent, if you are not sleeping over your rights, then the court comes to your rescue. Then you can approach the court and redress your grievances and claim reliefs. But if not, if you've been sleeping over your rights, then the court shall not come to your rescue. So there is a period of limitation that is prescribed for every activity under the Indian law. Now if the period of limitation runs out, if the period of limitation is over, then that specific activity which has been provided for under the Indian law gets time barred. That is, if there is an appeal that is to be preferred, an application to be filed, or if a suit is to be preferred before the respective courts, and if the period of limitation runs out, then that activity gets extinguished, and that specific application, appeal, or the suit, as the case may be, cannot be filed, and your right to sue gets extinguished. Now there are certain exceptions to that rule which have been provided for under Section 5 of the Limitation Act. Now Section 5 provides that any appeal or any application other than an application under any of the provisions of Order 21 of the Code of Civil Procedure may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period. Now one very important or very pertinent thing to note here, on the bare reading of the language of this section itself, is that there is no period of limitation, no extension of period of limitation for filing a suit, an appeal, or an application other than the application provided under Order 21 of the CPC. So therefore any appeal or application can have a condonation of delay being filed to it, but a suit cannot have a condonation of delay. So therefore, presuming that say you want to file a suit for recovery of money as against another person for recovering your money. Now the period of limitation prescribed for filing a suit for recovery of money is 3 years. So there, from the date on which the cause of action arises. So within 3 years that suit for recovery of money has to be filed. If it is beyond that, if it is even a day beyond that, then the suit gets time barred. So therefore there is no scope for filing of any condonation of delay there. Of course, that period of limitation of 3 years is subject to certain conditions also. That is, if in case there is something called as acknowledgement and extension of the period of limitation. That is, if within 3 years during when the period of limitation is running, if my debtor approaches me and gives it to me in writing or orally or through some means which can be proved before the court, that that person agrees to the fresh period of limitation running from that date of acknowledgement, then I get further 3 years. That is, to put it in simple words, if my debtor approaches me and says that I acknowledge your debt and I am willing to pay that entire amount, but I require some additional time. So if in that case another additional 3 years in case of suit for recovery of money shall be given to me. That is 2 years plus 3 years collectively. So I collectively get a period of limitation of 5 years. So that is another exception. I hope I was able to explain that. If that concept has not been understood clearly, then kindly make a mention of that in the comment section below, and I will try my best to explain that. So that is a case where extension of period of limitation for filing a suit can be is available. But other than that, if the period of limitation filing a suit extinguishes, there is no condonation of delay. Condonation of delay can be filed only with regards to an appeal and an application. So generally the period of limitation for preferring an appeal is 30 days, 60 days, as the case may be. So therefore, if a sufficient cause is given, then the period of limitation for filing that appeal can be extended. an appeal or any application, that is application such as say an application for bringing legal ads on record, the period of limitation prescribed therein is 90 days, within 90 days from the date of knowledge of death of that person. So therefore, if for whatever reason, if there is a sufficient cause for not performing the certain activity, that is bringing the legal ads on record, then the court can extend that time and permit the parties to bring the legal ads on record within the extended time. So therefore, any appeal or application other than an application under provisions of Order 21. Now, Order 21 of Civil Procedure Code deals with execution of decrees. So therefore, Order 21 has exclusively been excluded out of the extension of out of this particular provision. That is, execution has to be strictly construed. That is, if an application for execution is to be filed, there are certain specific period of limitations that have been prescribed, within which applications for execution of orders are to be filed. Now, another pertinent thing to note here is that for execution of any decree or any order of a civil code, the period of limitation is 12 years. So within 12 years, an application for execution of the order has to be filed from the date of passing of the judgment, order and decree, as the case may be. But what is important is, if an order granting injunction is passed as against the other party, then there is no period of limitation for it. There would be no period of limitation for executing the order of injunction so granted, because violation of injunction can happen anytime. It is otherwise the judgment debtor will systematically take advantage of the Limitation Act and wait for 12 years. I mean, if at all that is possible, and then start creating nuisance after the period of 12 years. So therefore, the decree holder will have to institute the same suit again and ask for the same reliefs as against the defendant. So that would lead to multiplicity of proceedings. So therefore, period of limitation for filing an execution application in respect of a decree of injunction, permanent injunction so granted, has been excluded. Now, an appeal or an application may be admitted if the applicant or the appellant satisfies the court that he had sufficient cause for not preferring the appeal or making the application. Now again, sufficient cause is a very vast and wide topic here, and there are multiple pronouncements of the Honorable Supreme Court and the various high courts of the country. So therefore, that is again a broad topic. So if you would like me to make a fresh video on that topic as well, kindly do make a mention of that in the description section. I'm sorry, in the comment section of this video, and I will try to make a separate video as regards that. But if I might briefly explain what sufficient cause is, the principles, as per the principles laid down by the Honorable Supreme Court and various high courts, sufficient cause is such that it is something that a person of ordinary prudence will be able to accept, and sufficient cause is not required to be, or rather the delay is not required to be explained day by day. That is, presuming that there is a delay of 3 months in preferring an appeal or any application as the case may be. So therefore, day by day justification as regards the delay is not required to be given. A sufficient cause, that is, if a person, that is to say that if the appellant was sick or was unwell or was hospitalized or had some kind of a family emergency which could not otherwise have been avoided, and because of which appeal could not have been preferred, so that becomes a sufficient ground, and on that basis the court can pardon the appellant from, or the applicant as the case may be, from strictly adhering by the laws of limitation, and that would fall within this ambit. So therefore, sufficient cause is something that has been specifically directed by the appellate court to be construed in such fashion so as to not, meaning the courts are not to delve into hair splitting technicalities when it comes to sufficient cause. Sufficient cause is to be broadly construed. I hope that makes sense. Further, the explanation given to the section is the fact that the appellant or the applicant was misled by any order, practice or judgment of the High Court in ascertaining or computing the prescribed period may be sufficient cause within the meaning of this section. So therefore, sometimes what happens is that when there is a suit before the trial court, and if an order is passed which is non-appealable, and if say a writ petition is filed, or for that matter if the order is an appealable order, and if an appeal is filed before the Honorable High Court, the High Courts, while disposing of the petition, sometimes make a mention as regards the period of limitation. So therefore, if the language of the judgment is such that it creates confusion, or sort of office procedure of issuing the certified copies, that is when the certified copy is kept ready, when the certified copy is to be collected, when it was filed for, if there is some confusion as regards that, then that also becomes a ground for the applicant to say that constitutes sufficient cause, and that the courts are to take due cognizance of that as well. So as I've previously pointed out, sufficient cause is sort of a broad term, and it is not to be construed very narrowly. So that is essentially the that is basically the precedent that has been set by the honorable appellate courts. So that is it for this video. If you found this video useful, kindly do give it a thumbs up. Kindly do share it with your friends if you think that they might find it useful, and don't forget to subscribe to this channel for more such content. This is Pritesh saying bye.